Welcome back to The Explainer. Okay, today we are diving into something absolutely huge. We're unpacking a highly debated, incredibly significant legal case that is literally sending shockwaves across Australia and testing the very boundaries of how the law defines identity. We're looking at the Giggle versus Tickle case, and I want to be super clear right off the bat. Our goal here is to look strictly at the source facts. We're not taking sides. Instead, we're going to trace exactly how a dispute over one single app's user policy escalated into this monumental clash over national and even international law.
Here's a quick roadmap for this explainer. We'll start with the Giggle versus Tickle case itself, unpack the federal court's ruling, trace the 2013 legal shift that made it possible, look at a really fascinating contrast with the UK, and wrap up with the political fallout. Let's get right into it.
Part 1. The Giggle versus Tickle case.
To understand this whole national conversation, we have to start at the micro level with one profoundly complex question that sits at the absolute center of this dispute. What is a woman? Honestly, how the law answers this single question completely dictates the entire chain of events we're about to explore.
So back in 2021, an entrepreneur named Sall Grover built a social networking app called Giggle for Girls. And despite its kind of lighthearted name, it quickly became the epicenter of a massive legal earthquake. The core premise, the foundational rule of this app, was that it was explicitly and exclusively a female-only space, built for women and only women. Well, that exclusivity was put to the test when Roxanne Tickle joined the platform. Roxanne is a biological male who identifies as a trans woman. And in 2021, Tickle was actually removed from the app by Sall Grover. Because of that removal, Roxanne Tickle launched a discrimination lawsuit against Grover, arguing that being kicked off the app directly violated the Sex Discrimination Act.
All right, Part 2, the federal court ruling.
Now, to really grasp the high stakes here, just look at this number, $120,000. The court ruled against Sall Grover, and the financial penalty was no joke. She was ordered to pay a six-figure sum, specifically $20,000 in compensation to Roxanne Tickle, plus legal costs that could reach up to $100,000.
The legal mechanics of how they got there are absolutely crucial. Initially, a lower court found indirect discrimination, but then the full bench of the federal court, led by Justice Melissa Perry, actually expanded on that. They ruled it was direct discrimination. They officially stated that the app treated Tickle less favorably than a woman designated female at birth. Basically, the court ruled that under Australian law, you cannot legally enforce a biological female-only space if it means excluding a trans woman. This brilliantly illustrates one clear side of this massive legal conflict. Take a look at this quote from the Sex Discrimination Commissioner, Dr. Anna Cody, reacting to the outcome. She said, "No one in Australia should face exclusion or discrimination based on sex or gender identity." So you can see the Commission's strong commitment here to protecting trans communities and gender identity rights under the law. But then, right away, you have to contrast that with Sall Grover's perspective. Her reaction was incredibly stark. She tweeted, "I am absolutely devastated. Men who claim to be women have more rights than actual women in Australia." Her argument is that biological women are actually the ones being discriminated against by losing their legally protected single-sex spaces. It's a total, head-on collision of two very different interpretations of human rights. Which brings us to Part 3, the 2013 legal shift. So you might be wondering, how did the court actually reach this verdict? Well, the real turning point happened over a decade ago. Back in 2013, Julia Gillard's government amended the Sex Discrimination Act. They essentially removed the strict legal definitions of man and woman, and, this is the key part, they inserted gender identity as a legally protected characteristic. It was exactly those 2013 amendments that laid the direct legal groundwork for the 2024 ruling. The judges were just applying the law as it was rewritten 11 years prior. Now, Sall Grover fiercely pushes back on how the court applied this law. She calls it an activist decision that totally lacked biological evidence and claims the judiciary has been captured by ideology. One of her biggest sticking points, she points out that the specific terms cisgender and transgender, which the judges heavily relied on in their decision, well, they don't actually appear anywhere in the text of the Sex Discrimination Act. She argues the judges made a deliberate choice rather than just following the strict letter of the law. Moving on to Part 4. The UK contrast. Let's zoom out for a second, because it is super revealing to look at this on a global scale. We're seeing some real jurisdictional friction here. While the Australian Federal Court is prioritizing gender identity based on those 2013 amendments, the UK Supreme Court recently went in the exact opposite direction. They handed down a unanimous ruling stating that references to sex in the UK Equality Act strictly mean biological sex at birth.
The real-world impact of that UK ruling is a completely different legal reality compared to Australia. Over in the UK, because of how they define sex, trans women can lawfully be excluded from single-sex spaces. We're talking about sensitive areas like changing rooms, homeless shelters, medical facilities. And get this, the British government actually welcomed the ruling, stating that single-sex spaces will always be protected in law. Literally the exact opposite of the Australian court stance.
Finally, Part 5. The political fallout.
As you can imagine, the political shockwaves from this single app case are massive, and the pressure to change Australian law is building fast. Opposition leader Angus Taylor has actually vowed that amending the Sex Discrimination Act to protect biological sex will be a first-term priority. You've got Senator Matt Canavan actively supporting bills to legislate male and female biological genders right back into the act to protect single-sex spaces, and this isn't just coming from one side of the aisle. Even former Greens leader Drew Hutton warned that if parties don't protect women-only spaces, there are going to be severe electoral consequences. And honestly, the legal battle itself is far from over. Sall Grover has made it clear she's going to seek leave to appeal this decision all the way up to the High Court of Australia, which means the highest court in the land might soon be forced to make a definitive ruling on these legal categories once and for all.
Which brings us right to the ultimate question I want to leave you with today. How does a society balance competing rights when defining protected legal categories? When the protection of gender identity directly collides with the legal boundaries of biological sex, whose rights prevail? This is a profound, ongoing tension in our legal system, and it extends way beyond a single app or one court case. It's an incredibly complex puzzle, and we're definitely going to see it unfold further in the coming months. Thanks for joining me for this explainer, and definitely keep an eye on the High Court, because this story is just getting started.